Welcome to my channel, All for Health with Jane. Family, the issue of new evidence that has to be led by Advocate Baloyi has been discussed in this court. It has been presented. Advocate Baloyi has applied. The defense has made their arguments. Judge Ratha has requested Baloyi to respond on the arguments and reasons that were given by the defense. Baloyi responded. After all having been done, then it is time for Judge Ratha to give his own ruling. So on this video, we are going to watch and listen as Judge Ratha is giving a ruling. I'm not going to say much about what Judge Ratha is going to say. We are all going to listen as Judge Ratha is doing that. Let's watch and listen, family.
Produced because it was not aware of the availability of that information, and this information relates to photographs, which photographs are allegedly those photographs of some of the accused before this court. The state has proffered reasons why it did not introduce this evidence earlier. And the most cogent reason is that there are photographs, thousands of photographs. It's not talking about 2 photographs, 6 photographs. Thousands of photographs which were downloaded according to the state in this matter. Apparently they are about, it's how much? 7,000?
For number 2, it's 5,467 files.
And then the others?
For accused number 3, it's over 700.
All right, and then the others?
Those are the only.
So in jointly, it's how many photographs?
It's in excess of 6,000.
Right. As any person with fairness can see, these are thousands and thousands of photographs. And the explanation given by the state is conceivably correct on the basis that it was only during the recess period when the court had recessed because there had to be preparation by accused number 1's counsel to prepare. Then that preparation took about, for a cross-examination, took about 4 months, 3 weeks. And it is during that time of preparation when the state alleges that it was trawling through these thousands of photographs that it came across evidence of the remainder of the photographs, which in perusal thereof the state thought it advisable to use that evidence. And the gravamen of the matter is that all the accused counsel had this evidence, all of them. They are not taken by surprise. All of them, they had this evidence. This court remembers it had to adjourn for about 2 weeks when all the counsel said they wanted to peruse the photographs. So the state is arguing that this evidence is relevant, and the defense is arguing the contrary, that this evidence is not relevant. It is new evidence. And the premise of the law is as follows. Irrelevant evidence is inadmissible. No evidence as to any fact, matter, or thing shall be admissible which is irrelevant or immaterial and which cannot conduce to prove or disprove any point of fact at issue in criminal proceedings. And I'm reading this from the TOIT, if you want to read it, page 2422B. The meaning of relevance. The relevance of an item of evidence refers to its logical tendency to show or indicate the material fact for which the evidence is offered. See, in this regard, the case of R versus Katz, 1946 AD 71 to 77, where Watermeyer, who was then the Chief Justice, approved the following definition by Stephen Digest of the Law of Evidence, 11th edition, 1930, Article 1. I repeat, the word relevant meant that any two facts to which it is applied are so related to each other that according to the common sense of events, either taken by itself or in connection with other facts, proves or renders probable the past, present, or future existence or non-existence of the other. Here we're talking about photographs. So we're not talking about hypothetical evidence. We're talking about material photographs. And as I listen to the argument of the defense of the accused is not affected in essence. In other words, the defense of the accused remains the same. They know nothing about the so-called alleged murder of the deceased. They were not there at any time. They know nothing about that. So the defense remains constant and consistent. So the prejudice, if any, is it has been tendered at a later stage, but the state has proffered compelling and compellable evidence that this evidence, although it can be categorized as new, it has relevance to this case, and it is related to all the evidence that has been led in this case, that of photographs. And we talked about the photographs being about 5,000 or 7,000. And there is no ambush, because according to Mr. Baloyi, on behalf of the state, 3 weeks or so, the same photographs which were discovered by Mr. Malone was tendered to all the defense counsels, and they were advised that the state intends leading that evidence. So let's see if this evidence is now taken out of a hat like a rabbit of a magician. According to Baloyi, it was tendered, there were discussions, there were postponement of the discussions, and when I listened to the two parties, they met, but somebody was saying, no, you're lying, the other one saying, no, it's not true, etc., etc. But the fact of the matter is, no person was ambushed. Okay. Now, this court is persuaded because the state is saying this evidence is relevant and it is connected to the case, and it doesn't materially change, according to the defense proffered by the accused. They pleaded not guilty, and they proffered, during the cross-examination of some of the witnesses, they proffered defenses which range from, we were not there, we know nothing about that, the state's evidence is not correct, etc., etc. Consequently, in the interest of justice, the court admits that the state is entitled to lead those two witnesses if it so desires, and the application is acceded to.
There we are, family. In conclusion, Judge Ratha is admitting, he has made an admission to the fact that Advocate Baloyi can lead this new evidence in court. So, family, there we are. Thank you so much for watching this video to the end. Please like it before you leave. Subscribe if you haven't done so yet. Thank you, family. Bye.